Good evening, friends. Namaskar. Welcome to Lawyer's Voice. I extend a very warm welcome to all our viewers this evening. Exactly a month ago, on the 10th of June, the Union Finance Ministry proposed to decriminalize certain sections of various legislations, to be precise, exactly 19 in number, and asked for certain suggestions from the public. Well, on one hand, it is being seen to be a helping hand to various businesses, especially medium and small businesses. On the other hand, it is also being felt that it might take away the only weapon that is there in the hands of lenders who lend money to various debtors. Now, who will this impact largely, these decisions? Will companies be impacted? Will small business owners be impacted? So to discuss this and to have this enriching discussion today, we have with us three extremely distinguished speakers. On one hand, the geopolitical angle is also to be looked at, where we see that the trust that China enjoyed at once upon a time in this world is going down, is diminishing. Looking in that instance, taking that into light, can India as a country, as an economy, take advantage of this situation? At this stage, today we are at number 63 in the ease of doing business, and we are not very far from China, which is at 31. So we'll begin the discussion. Before that, I would like to introduce Mr. Sumit Nagpal, who is one of the leading names in media law and intellectual property right. He also has a channel which regularly conducts webinars on extremely important and informative issues. So with this, I would like to invite Sumit Nagpalji to give a brief introduction of Lawyer's Voice and the purpose of our all gathered here this evening today. Sumitji.
Hi, Shamandu, and I welcome all the guests, esteemed guests, who are going to join this particular discussion. And I can say that I'm absolutely delighted that Lawyers' Voice has taken up this issue. It's an organization which is by the lawyers, for the lawyers, and it is not only working when it comes to academic discussion on various aspects. Lawyers' Voice is also raising important public issues by filing public interest litigations, and it is working under the guidance of Mr. Neeraj, who is heading this organization. Mr. Abhay, he is also the person who is leading this organization. And I can say that if any lawyer who is watching this broadcast, who wants to be a part of the academic discussion or who wants to be a part of cultural activities, he can certainly come and join Lawyers' Voice. And I can say that this is a great honor for me. This is a great opportunity for all the lawyers to be a part of this organization. We conduct discussions. We already had a discussion on fake news, and this is the second important topic we are having a discussion on. And I can say that very best wishes for conducting this discussion, and I really hope that we'll be able to have some fruitful conclusions drawn out of this particular discussion. Charanjot.
Thank you, sir. And as Sumit sir rightly said, we last month in May, on 31st of May, we had our first session, which was on fake news, and we were graced by none other than Justice Badr Durraiz Ahmed, who was the Chief Justice of Jammu Kashmir High Court and a very popular judge at the Delhi High Court. We had Mr. Bhupender Chaubey, who is an eminent journalist, and we had Mr. Chetan Sharma, who has just been appointed as the Additional Solicitor General at the Delhi High Court. Viewers, economic revival has been a priority for this government, and some of the sections that have been decriminalized or proposed to be decriminalized are notably Section 12 of the Insurance Act, Section 29 of the SARFAESI Act, Banking Regulation Act, Chit Funds Act, Negotiable Instruments Act, which is largely talked about Section 58 of the RBI Act, Section 42 of the State Financial Corporation Act, amongst others. To start the discussion today, I would like to introduce Mr. Abhay Bhardwaj, who is a senior advocate and an honorable member of Parliament. Sir was enrolled as an advocate in the year 1980, and he's a former member of the Law Commission of India. And to his credit, various important legislations are also given. He was also involved in the drafting of the Triple Talaq legislation, and he has represented the state of Gujarat as a special public prosecutor, and has also been author of various books. With this, I invite Mr. Abhay Bhardwaj to initiate the discussion today. Over to you, sir.
The question which has been posed, the word decriminalization has caused a lot of misunderstanding. Practically, in today's criminal jurisprudence and even in today's criminal courts, we have section 125 of the CRPC, which deals with the maintenance, and still it is a civil litigation. In the same manner, we have Domestic Violence Act decided by the magistrates. Still, it is a civil litigation, kind of a civil nature litigation. The only nature is changing. The statute is not changing. We are not changing the penal code, or we are not changing the penal provisions as such. Basically, what we say, they are not being removed from the penal, what we call books, handbooks. There is a misunderstanding that the whole law is being hooked out or booked out or thrown out. No, it is not so. I tell you one thing very frankly, that I was going through the proposals of the industries. Nowhere the industry has mentioned, they have given 12 suggestions, and nowhere they have mentioned that the law should be thrown out, or they have never said that the action should not be taken, or the lender should be in problem, or the borrower should enjoy. No, no, nowhere. The industry has very clearly, specifically mentioned that they want a buffer before some criminal initiation or action. They want a buffer of adjudication. They want a buffer of mediation. They want a buffer wherein they can put their situation, correct the situation, and basically they want a correcting or a correction method. Nowhere the industry has demanded that this particular penal section should be removed from the books, or no, it is not so. On the contrary, they have tried to bring more and more legal brains into this issue, because they want a pre-trial mediation, they want a pre-trial discussion, and they want, before the matter goes for a criminal trial or the criminal initiation of trial, I think their pre-mediation is what they desire and what they demand. And I think there is nothing wrong in that. Had there be pre-mediation even in IPC or pre-charge conferences in IPC, I think most of the cases could have been solved there by monetary considerations. And that is what exactly has been said by the Supreme Court, which is often misquoted. Even in 138 cases, the Supreme Court was very clear. It stated that this is a revenue earning. Basically, the intention is to collect money, and that is why it is practically civil in nature, in a sense. Now, if there is an understanding or there is a misunderstanding that this particular things by decriminalization word would be out of the focus, no. Practically, the punishment changes from imprisonment to the civil punishment, to the civil penalty. In fact, the penalty is still there. Penalty can be inflicted. I tell you, so far example of 138 is concerned, at present, when a person dies, his estate cannot be attached, his family cannot be brought into picture. But if it is kind of a made into quasi-civil penalty, the family can be brought in, his estate can be brought in, and like attachment before judgment, we can have a lot of things which may be civil, but still we can have it before the adjudicating authority, who can act more strongly. Practically, what I understand from the industry demand was, they want an adjudicating body before it goes criminal. And I can understand this very simply, because there are so many foreign companies who have their holding in Indian companies. And Indian companies, people concerned with the administration, issue checks. When they issue checks, they may bounce back. And ultimately, those foreign directors or the foreign holding people will be dragged into in the Indian courts. And that is why they are trying to avoid this. Similarly, in chit fund, there may be directors from the foreign companies or foreign countries. There may be foreign investment also. But when the check bounces or something happens wrong here, they will be held liable for whatever has been done by their counterpart here in India. And that is why they are shying away, practically we can say, from investing and from the Indian courts in a sense. I think police world has to be removed from all these civil wrongs or the criminal wrongs which are kind of a civil wrongs. The police itself word causes a lot of problem. And as I understand, the Supreme Court has suggested to the government for summary trials of 138, for summary trials of all the offences which are connected with the economic activity. There may be cases where the person may not have intended. There may be cases when there would not be mens rea, but by inadvertently they might have done something. And secondly, the lawyer should not be afraid because you are more in picture, in the sense that IPC is not taken away, 415 to 419.20 is not taken away, 460C to 470.71 is not taken away. There are all frauds, forgeries are governed by the Indian Penal Code, and it is still there. There are cases where false certificates are filed, they are covered with the Indian Penal Code sections from 170 onwards. All these kind of offences are covered. Question is, these offences are summarizable or non-cognizable. The cognizable offences word, when it is used, is it misused by police machinery sometimes? Not always, but sometimes. Now, although a complaint is provided and the jurisdiction is given to the court by taking cognizance on a complaint only, this which would clearly mean that police is out of picture, although cognizable word might have been used. But this is the circumstances which make these people away, and that is why when you are trying to use the word decriminalization, it is practically a penalty which is being changed into the form from imprisonment to the penalty to more vigorous penalties. Recently, we had example of Nirav Modi's attachment. Even Malia is prepared to pay every pie. Why? Because the laws, basically the Indian laws, are so strong that even if you do not go by any special civil criminal proceedings, still the property can be attached, property can be recovered. In the similar manner, the word decriminalization has practically has a wrong notion. Practically, we have tried to understand it wrongly and in the wrong manner. There is no reason to be afraid of it. Nothing is going to be lost by the lenders, or nothing is to be borrowers to be afraid of. The question is very simple. Sometimes unprecedented circumstances want unprecedented solutions. This question arose only because of the situation that China is going away, India is coming in, and if India is to remain in, then it has to secure the foreign investors, the foreign people who companies, and they can only be assured if they are sure that no criminal action will be taken against them for their investment or for their part of investment, or no Indian court will drag them into criminal proceedings. And this unprecedented circumstances makes India number one destination for the foreign investments. And we must understand this. And in this unprecedented circumstances, as an arrangement, as a way of making India stronger economically, these suggestions are being made. Still, it is very clearly laid down that all can have their suggestions. Some lower bodies, as I understand, have objected to 138. 138, it is not going to be removed. On the contrary, you will be there always. On the contrary, you will take part in all adjudication proceedings. On the contrary, your client, if he is a lender, can from the estate of the person recover the things. So I think so. I would like to begin with these things and make it implicitly clear that the government never intended, or nobody is desiring, not even the industry has said that these provisions be brought out or these provisions should not be there. It is just said that there should be a buffer, there should be an in-between agency. And they have also said that the civil penalty may be there. They have also said that before criminal proceedings are initiated, a pre-mediation may be there. I think there is nothing wrong. We have already gone for pre-mediation. Thank you very much for allowing me to speak to you all. And thank you, Mr. Mukherjee.
Thank you, sir. Thank you so much for your opening remarks. Certain very thought-provoking points that you've raised. And I'm sure as this discussion grows and as this discussion builds, we'll come up with even more fruitful suggestions for the future going forward. You've raised certain good points about the pre-mediation point and that there are already civil remedies, and also on the point that it will be tempting or it would be advantageous to foreign investors now, especially that India is trying to rise and get a stronger foothold in global trade. So I'm sure these points we can discuss further. With this, Mr. Bhardwaj, thank you so much. I would now like to introduce our very reputed chartered accountant with us, CA Nanda sir, who is here. A short introduction if I would like to give for sir. Sir has been a practicing chartered accountant since 1991 and has interests in the field of capital market, human relation management, corporate laws, audit and management consultancy. He is currently the Central Council member of the Institute of Chartered Accountants of India. Sir has been chairman of the Internal Audit Standard Board, as well as the vice chairman of Banking, Financial Services and Insurance Committee of the ICAI. Sir was nominated to the IRDA Steering Committee for implementation of the risk-based capital regime, and he has also been chairman of the Committee of the Cooperative and NPO sectors. With this few words, I'm sure the sir's introduction is a lengthy one. I've just touched upon the very brief points so that we don't keep sir away from the audience. So sir, over to you for your introductory remarks on this topic of this evening. Sir.
Thank you so much, Mr. Mukherjee. My very greatest compliments to Shri Neeraj, his entire team, and the Lawyer's Voice. I am very much impressed to see that the contemporary topics which are chosen for deliberation, they are of great interest to all professionals, and I shall, during my discussion, dwell upon the economic aspect of the entire thing. Before I start my views on decriminalization has created a lot of flutter. The reason is very simple, and if it can be explained by way of a couplet, the couplet could be: पानी में अक्स देखकर इतरा रहा था मैं, पानी में अक्स देखकर इतरा रहा था मैं, कंकड़ किसी ने फेंक के मंजर बदल दिया. The entire opposition to this is opposition to change. People don't want change. I'll give you the perspective why decriminalization is important. Decriminalization is in line with the government's stated goal of promoting ease of doing business. The Company Law Board Committee, CLC, set up by the Ministry of Corporate Affairs, very recently submitted its report to the MCA, recommending decriminalization of 46 offences under the Companies Act 2013. This list, number of people will not know, is in addition to the 16 compoundable offences already decriminalized under the Companies Amendment Act 2019. To put things into the perspective, let me tell you that attempts to decriminalize business laws is not new to India. This process began with the liberalization of Indian economy in 1991. The first commercial law that was decriminalized was the Foreign Trade Development and Regulation Act 1992, which decriminalized almost most of the sections related to import and export. The most fundamental step in this direction was the replacement of the draconian Foreign Exchange Regulation Act, FERA 1973, by a very simple and logical act, Foreign Exchange Management Act, FEMA 1999, which decriminalized offences related to foreign exchange regulations. Let us be very frank. There is no denying of the fact that India's criminal justice system is badly choked. and it typically takes several years to get a final outcome. So in principle, any step taken by MCA to declog the criminal justice system is a step in the right direction. The basic impetus before the government is to ensure that the improvement of business sentiments occur. And we have to understand that in Indian context, it is very advisable that the laws strike a healthy balance between civil and criminal corporate sanctions. Offenses that involve misuse of substantial amount of public money is separate. They need to be dealt with under regular criminal justice system. But largely, if there are certain minor offenses, they could be taken care in a different manner altogether. I'll take you now on some very basic aspects. You are aware that the Ministry of Corporate Affairs brought this to ensure that the entire system, which is put in perspective, is largely, it started with the recommendation of report of the committee to review offenses under the Companies Act 2013. One more important thing, that the 2019 amendment eliminates the criminality of these violations by levying monetary penalties instead of criminal fines. Although decriminalization is very keen that punishments or penalties may be in penal offenses, whether monetary or imprisonment, both have to go. And now I'll come to a specific issue. Levying these penalties has also been shifted from courts to in-house adjudication mechanism, which we very commonly call as IAM, under section 454 of the Act. What is the procedure? Whereby adjudicating officers appointed by the central government determine the offense and enable companies to promptly communicate, represent and resolve defaults. They were brought in by the Companies Amendment Ordinance 2018 and Companies Amendment Ordinance 2019 and the Companies Amendment Second Order Ordinance 2019. So largely we need to understand that the greater ease of living to law-abiding companies. We need foreign investors to come in. You are well aware that capital is an issue. We want foreign investors to come in. And the foreign investors feel that if decriminalization is there, they are able to work in a better work. They are able to work in a better environment and perform to the largest level. World has now become a global village. And in such circumstances, we need capital from other countries to come in, plow our fields and make our youth. We have so many things to our credit. We have the young populations in abundance. We have people with great impetus, great knowledge. Our knowledge of English, our skills of English, our software skills, they are immense. But we need a congenial ground for the international funding agencies to come in and work. So we have to understand that the criminal prosecutions are largely time-consuming and complex. Accordingly, some scholars urge for criminal offenses to be completely replaced by civil prosecution. Another school of thought also recommended that penalties are not commensurate with the offense or default and may at times be counterproductive and instead could incentivize non-compliance. So in order to keep things in a normal pace, to give them an incentive of compliance, this thing has come in. Now I'll tell you the benefit. The biggest benefit comes to the independent directors. You are aware that on boards of all companies, there have to be independent directors. The independent directors have recently been in spot for personal liabilities of lapses and violations. Now, these amendments are vital for independent directors to dissociate them from personal liabilities, especially when the offense has been committed without any evidence attributing knowledge, consent, connivance, or lack of diligence of the independent directors. A board is run by certain people. Other than the promoter, there are professional people on the board who run the companies. So they also need to be living in a fear-free environment where they understand that they're working. If it is directed towards a particular direction, should give them immense opportunities of performing and taking the company to unprecedented heights, and at the same time make them immune for certain things for which they are not at all responsible. The ministry came out with a notification on March 2nd, 2020. It directs that similar criminal proceedings not to be unnecessarily initiating against the independent directors unless there is sufficient evidence, and if it is already initiated, it again needs to be reviewed. So please understand, decriminalization is such thing which will have lot of benefits. I can tell you, the most important thing in decriminalization is a chance for people who want to perform to sit back, relax and then perform. थोड़ा सा निखर जाऊं, यही मैंने ठानी है. थोड़ा सा निखर जाऊं, यही मैंने ठानी है. ऐ जिंदगी थोड़ा रुक, अभी हार कहाँ मानी है. Boards need people to perform. Board needs people where valuations are proper so that foreign investors come in to invest. And these amendments are admirable steps towards three prolonged goals. Number one, reducing the burden on company courts, which are overburdened at the moment. The second, ensuring investors' interest, which is again paramount if you want to give a conducive environment for the business to flourish. And third, facilitating the ease of doing business while collaterally safeguarding and incentivizing senior management to remain invested. Nobody would like to come in and invest if he feels that there are certain loopholes. Those loopholes essentially need to be plugged. This could well be the step towards showing intent to invest, incentivize domestic and global investments, especially post-COVID-19. COVID-19 has created a lot of problems. So in order to go ahead in that, we need a policy direction. So in terms of larger policy direction, I would like to state that businesses have been very significantly affected by pandemic. All of you are aware, even our professionals of chartered accountancy, lawyers and others are also affected a lot by the movements have been restrained and certain things have stepped in. So the onerous regulatory regime has sought to be eased in its way. The Fresh Start scheme, providing the condonation of delay for filing of regulatory nature and to provide immunity where investigations or parallel proceedings for the delays has already been initiated by the registrar of companies. So on similar note, compliance requirements under SEBI, issue of capital and disclosure requirements, regulation 2018 were relaxed for rights offering. This is all a movement into this. So even beyond COVID-19, an overhaul of the regulatory framework as being currently proposed is only the second of such initiatives. We have to work in this direction and ensure that whatever we do is giving a congenial atmosphere for all to flourish. The improvement of business sentiments is of paramount importance. The ease of doing business, coupled with all regulatory support which we can give, will give an environment for the country to go ahead and encourage entrepreneurs, startups, and foreign investors also to come in and make their contribution to make India a great company, to ensure that it reaches unprecedented heights and works towards the desired objective of inclusive growth for one and all. So I shall be open to question answers if any. Thank you. Thank you so much.
Thank you, sir. Extremely fascinating, and the points that you've touched upon, I think the comments that we are receiving from our audience, it's extremely fascinating for me as a young advocate, as well as for our friends, young and old. With your very ingenious way, with couplets, you've so magnificently explained the whole topic, and you've touched upon all the basic points that we had raised for discussion today. Thank you so much, sir. We'll come back to you during the question session. With this, we would like to now move to our third speaker, and we have none other than Mr. Ranjit Kumar. Sir is a very celebrated lawyer, advocate. He was appointed as the Solicitor General of India in the year 2014. Sir is considered as an expert in constitutional laws, service matters, taxation, local laws relating to rent control. Sir has appeared in various high-profile matters involving and on behalf of the Government of India, as well as the Central Bureau of Investigation, as well as an amicus curiae. Sir had previously played an instrumental role in assisting the Supreme Court in prescribing a series of directives that eventually led to Delhi's public transport switching to a cleaner fuel way back in the early 2000s. Sir has, apart from this, appeared in the Vyapam matters as well as most recently in the Ayodhya hearings. Sir has also appeared for the CBI involving Lalu Prasad Yadav and had appeared in the disproportionate assets case involving former Chief Minister of Tamil Nadu, J. Jayalalitha. And Sir has also been counsel for the Gujarat government in the Sohrabuddin case as well. So without much further ado, I would like to invite Mr. Ranjit Kumar Sir for taking this discussion forward, which has been so beautifully thrown open by Mr. Abhay Bhardwaj and CJS Nanda. Over to you, sir.
Thank you. Namaskar to everybody. Well, the topic is very interesting with the word used as decriminalization. I may also just make one observation here that I am not privy to what the suggestions have come forward with reference to the issues referred qua the sections in question which have been referred to me qua decriminalization as to what the government intends to do. My friends, Mr. Bhardwaj is an MP and he may be having privy to it. Mr. Nanda is also an eminent chartered accountant and he's on boards of various institutions, so he's privy to what may have been contemplated. So I don't know about those contemplations, so I will skip. I will just concentrate on the law as such, as it exists, and what the effect could or could not be. With that preface, I will just first start that courts in this country are clogged with every kind of matter, whether it is civil, criminal, taxation, or any other law. There is huge pendency. So to switch over from a criminal law to a civil law, or to think of that there could be a civil liability and not a criminal liability, is just shifting the burden from one to another without any recourse. So I don't accept this theory that decriminalization to the effect that you change. What is criminalization? What is an offense is defined under the CRPC. And what is an offense? Somebody does something which is illegal, fraudulent, dishonestly, etc. are offenses which are being committed, and the requirement is only that it should have been willfully, dishonestly done. So somebody does something like that willfully or dishonestly, whether he is a foreigner or an Indian, why should he get away from it? That's the most important aspect according to me. Every offender, merely because he is a foreigner, so the Indian party will take the blame and the foreigner will go scot-free, is not something right. But what is right is the pre-trial mediation, the pre-charge mediation, and the concept of plea bargaining. As most of you may be aware, in criminal law, plea bargaining has already been introduced in chapter 21A of the CRPC. There is a provision to do plea bargaining. People with less than 7 years of sentence, where the sentence prescribed is less than 7 years, can enter into a plea bargain before the court, and there the liability then reduces. So that whole chapter is required to be seen. So are we really wanting to change so many laws and not look at what we already have in existence in the form of plea bargain is a question. Ease of business is right. People must be free to do business. But why is it that the changes are not contemplated in the Income Tax Act or the Goods and Service Act or the Sales Tax Act, the liability there is still there. So, and what do you see as a minor offense? Now, question is that cognizable and non-cognizable offenses are those where cognizable, your person can be arrested without warrant, and non-cognizable are those where a person cannot be arrested without warrant. Then there are summons cases and warrants cases. Summons cases are those who are below 2 years of imprisonment, and warrant cases are those more than 2 years. So therefore, there is already a system of check and balance as to whether a person can be harassed or not. Criminal courts are as much busy or more busy as civil cases. Now, I will take an example. If you were to remove under the Factoring Act, Factoring Act, there is a proposal to remove Section 23. Now, what is factoring? Factoring is when you supply goods to somebody on credit, and the credit will come after 30 or 45 days, and you can't wait that long. So a person who is a factoring agent will come forward and say, I will take your invoice, I will pay you the bills, whatever, I will charge a certain commission, your money I will receive today, and I will collect it from the person whom you was to pay you after 30 days or 45 days or 90 days, whatever be the credit line. Now imagine if that factoring, the liability goes away under of any dishonest intention. The person who had to receive the money has got it, but that agent who is providing the credit line, or a factoring agent, he could be fighting in court for years to come to get back his money. A suit for recovery of money can go on for more than 20 years in our country. So what we need to do is upgrade our judicial system. Merely because their laws are always in place, laws and laws and laws, it is the implementation of the laws which is an issue. So therefore, I have this, that I fully agree that there should be pre-trial mediation, there could be pre-charge mediation, but it ought not to be that an offender who has willfully, dishonestly, with all illegal intention, with the mens rea, should get away scot-free. I take the example of 138 cases. Of course, I was told that 138 is not going anywhere, but I am just saying that what papers I have received from my friends here who have got the program on, it says that if supposing a check is bounced, now why would somebody be paying a check? The payor and the payee needs that money because he has supplied goods or service. Now if the payor dishonors that check and therefore the money is not transferred, there will be more problems with the business community. So the ease of doing business is not there. The person who needs the money, he has supplied his goods, he has supplied his service, check is dishonored. Where does he get the money from? So that part of the business totally goes blank. He has to fight and apply for recovery of money, whether in a civil suit or whatever otherwise is being proposed. So we have to really apply our mind as to what we are getting into. Merely because foreign investment has to come, that should not, in my respectful submission, should be such a way that the foreigner has no liability and the person here may suffer, or the courts here will be able to adjudicate. That is why today we have arbitration going on in a very big way. Mediations have also taken a very large stage today. Most high courts, etc., are asking people to go for mediation if there are issues under the CPC. There is a provision in the CPC section 89 that you can go for mediation. So mediation is definitely a way, arbitration is definitely a way, but if somebody does something dishonestly, intentionally, fraudulently, I don't think he should be allowed to escape the rigors of the law, whether he's a foreigner or not. That's one thing. The second thing is that if you take away the deterrent effect, what happens in our with the greatest respect to our democracy, people here are used to doing things which they ought not to do. It is the law which deters them from doing certain things which they should not do. Now, if the deterrent law is taken away, if the person concerned is not afraid of the law, or there is lawlessness because he feels I can get away with anything, then the deterrent having been taken away, he will still not follow the law. I would say this is, with my little experience at the bar, that even with the deterrent which is there, people are not willing to follow the law. Look at the check bouncing cases. There are maybe more than 50 lakh cases on check dishonor cases which are pending in different courts. So even with that deterrent, if they have so much, what would happen if you take away the deterrent? So I am just giving an example. I don't know whether it will happen in the Negotiable Instruments Act or not. So I don't agree. Now, if you see the definitions under the IPC, good faith is defined, illegal or legally bound to do is defined, what is the intention is defined, acts and omissions are defined. So the word fraudulently is defined. All these things are already defined. Now, you are saying some section says that if what paper I have received, it says here that somebody who makes a false claim under the Actuaries Act. Now, this is some section which is sought to be taken away. Now, if he makes a false representation, why should he not be punished? If there is no deterrent qua false representation, then the people will be, I think there will be more cheating and more people will get into this. So let us concentrate on plea bargaining, which chapter we have already got in the CRPC. Maybe there may be some requirement to brush it and fine tune it in line with the investment proposals that we have. Let us also concentrate on pre-trial mediation and pre-charge mediation. That is a good thing, that people will come forward. It happens all over the world and it can happen here also. But I somehow feel that a wrong committed by a person should not be forsaken because he is bringing in investment. That may not, because if he comes with that intention that I will make some investment as if I am throwing money to the country and I can get away with murder, that according to me is not acceptable so far as in my view. That so these are my views on the subject, and I thank you all for your opportunity to speak here. Thank you, Shomendu, Neeraj, and Lawyer's Voice for listening to my voice. Thank you.
Thank you, sir. What is most important is all voices must be heard, whether that be in favor or be not in favor, but suggestions are always welcome. That is the beauty of this forum. That at one hand, we have to revive the economy. On the other hand, we have to invite investors, but we cannot, as you rightly gave an example, that one cannot be allowed to let go with murder just because he's bringing money into the economy, which is very pertinent and very good points raised. So with this, I would like to take the discussion forward. And now, at this stage, I would just like to throw the floor open to certain questions. We have some young friends with us today who have joined us and would like to ask questions to the speakers. How we would like to deal this from here right now is, we'll have a question, and any of the speakers who want to address any other points that have been raised by other speakers can also come in and answer that. So that will give us a wholesome picture of things that can be taken away from this discussion by all of us. So with this, I would like to invite Mr. Kunal Punj, who has a question I would first just like to bring Kunal on screen. Kunal, good evening.
Good evening, everyone.
Yes, Kunal, may I know who would you like to ask the question to?
My question is for Mr. Nanda.
Okay, okay, Mr. Nanda, the question is to you. Kunal,
Yes,
please,
please go ahead, Mr. Punj. I'm there.
So
you can.
my question is with RBI receiving 5,200 complaints related to chit fund scam since 2016, and with the huge financial illiteracy in India, how investors' interest will be protected if Section 76 of Chit Fund Act 1982 and Section 21 of the Undergraduate Deposit Scheme 2019 is decriminalized?
You have a very pertinent question, Mr. Punj.
Yes, sir.
And you know, I'm in the habit of saying couplets. So I will start this by a couplet. The couplet says, हम चिरागों की भला कैसे हिफाजत करते, हम चिरागों की भला कैसे हिफाजत करते, ये वक्त तो सूरज को भी हर रोज बुझा दिया करता है. We have to understand one thing very candidly. You have to have the faith on the finer sense of the legislation. There are certain issues that need to be addressed before this sees the light of the day. There can be issues in civil liabilities. The offenses may be compoundable because you have to look how many cases are there and what is the rate of prosecution. How many people are able to get their money. We have to ultimately usher in an era where all offenses are holistically taken into account and redressed appropriately. Although it is something which people may not agree on various forums. But I am fully sure that times will come when very maturely we will try to, because this is a step in that direction only. This is a decriminalization of certain sections to ensure that litigation is stopped. But still at the time, justice cannot be denied. We have to understand, decriminalization never opts for a place where justice is denied. We have no place for dishonest, for unlawful, for fraudulent, for people who do things deliberately. But we are looking at the same time towards speedy resolution of the entire thing. And that is why these legislations are aimed at. I can't comment something now because all things are not clear. But I have full respect for my legislators that whatever has been brought out would have done after complete discussions and ensuring that justice is meted out to people who are aggrieved. Thank you.
Thank you, sir, for your answer. If you have anything to add or to respond to what Mr. Ranjit Kumar has said, because he also raised certain very important points, or any points that have been raised by Bhardwaj, sir, if you would like to address them now, or we can move to the next question. If there is anything in your mind.
I would just like to say that it was a very holistically created program. All people with different views. Mr. Ranjit had his own views, Mr. Bhardwaj has his own views. So all come down to a single place. Right. The feedback starts. The most important thing is the public voice at that time. If people air their views, then there can be suitable redressal of the views. That is important. So if a white paper on this can be given to the government so that the government can understand these are the pain areas and how they need to redress them. This is my simple view.
Thank you, sir. With this, I move to my second young friend of mine, which is Damini Garg. Damini has a question. Damini, who would you like to ask your question to?
Sir, my question is to Ranjit sir.
Okay, I'll just get Ranjit sir on screen. Damini, please go ahead.
Sir, my question is, unprecedented times do call for unprecedented solutions. However, do you think the system will be able to absorb the shock of the paradigm shift, especially when we talk about decriminalizing non-compliance provision of the SARFAESI?
Well, thank you for your question, Damini.
Thank you, sir.
What is SARFAESI? Let us understand. SARFAESI is a provision where banks and creditors who have given money to people, but the persons are not willing to return that money and they become defaulters. If they are defaulters and are unable to pay money, there is first a scheme that you can have a mutual agreed terms and extend the payment schedule, etc. But if you don't do so and you just go away and say I will not pay, then against the assets which have been created by the money which was taken, those assets are taken care of for the purpose of satisfying the amount that has been taken as loan. So what is surfaces securities interest? Security interest is what you give as mortgage for the money that you took borrowed from a bank or a financial institution. So the question is, why are we having so much NPA? We are talking of so many companies having NPA that it is mind-boggling. Some 3 lakh, 4 lakh, 5 lakh crore rupees are stuck because companies have become NPA. So now you are talking about that these are times which are bad. So I agree with you that because these times have been bad, the economy is facing a little downhill, and it will definitely bounce back, and I'm sure the economy will reach its height with all what the Prime Minister, the Honorable Prime Minister and the Honorable Finance Minister have done in infusing money and resources and all kinds of schemes, that the economy will revive. But pending that revival and pending a positive growth, I feel that the concerned DRTs, the Debt Recovery Tribunals, or even the Ministry of Company Affairs, under which the DRT functions, can give a recommendation, or even the RBI can say that, and some steps have already been taken, that the interest amount for the period during which the lockdown was or the company is suffering, you can waive the interest or you can lower the interest. That is one. You can also say that proceedings will stay in abeyance for now for a certain period, as some, I think that Company Law Tribunal maybe has done. I am not fully sure about that. So some sort of measures should be taken because of the pandemic, so that the people who even have a schedule to pay, maybe somebody has agreed that I will pay by this schedule and reschedule the whole payment system, but he is still not able to do, then he can be given some relief because the pandemic has brought about losses. So I agree with you, but it can't be that a person who has taken away money just walks out and the whole thing becomes NPA and the money cannot be recovered to the financial institution, because these very financial institutions and banks will then lend money to somebody else if they get back that money. Otherwise, it can't be that the government will keep funding the banks and the financial institutions and giving lakhs of crores, and people will make it NPA and keep walking away. That's how I like to answer your question.
Right, sir. Thank you so much. And now I believe we have a question for our first speaker of the evening, Mr. Abhay Bhardwaj. And before I would like to proceed, I must take this opportunity to congratulate sir for being elected to the Rajya Sabha, which is the upper house. And today it is sir's first visit to Delhi after being elected, my apologies, and to complete certain formalities. So I wish sir a very successful and healthy tenure at the upper house, and may he continue with his invaluable contributions to the legislative process and system of our country. With this, I would like to invite our next young friend, Mr. Kumar. I believe he has a question for Mr. Bhardwaj. Kamal, please go ahead.
Good evening, sir. My question to you is that if Section 138 of Negotiable Instrument Act is being decriminalized, will it not affect businesses due to the increasing possibility of dishonor of checks?
Sir, before
you
answer that, I would just remind you, if you have any points to reply to our different other speakers, you're free to do that as well.
No, I would not like to reply to anyone, but my answer will be the reply to myself. Brother, I would like to tell you one thing. The magistrates are not going. They are going to remain.
Yes.
The cases are going to be conducted by the magistrates themselves. Only the forum has changed, or the forum is sought to be changed. From a imprisonment, civil penalties to be inflicted. That is what is going to happen. Even in 2013 Law Commission report, it has been said that 40 lakh cases are pending in different courts. Even today, 6 to 7,000 cases every day are unregistered because of the pandemic. If the pandemic goes, what will be the situation there? So we are not decriminalized. Yes, the word is, I think, something misunderstood. It is practically de-horrorization, if you understand. There is a horror and terror which we won't like to de-horrorize or de-terrorize the people from these who are connected with the economic community. And even the industries have demanded speedy trial, summary trial. But they only sought that imprisonment may be removed and penalty may be put. Even today, you cannot, even in today's courts, you cannot get the money from estate. Do you get it? No. 138 doesn't provide that. Only it provides for imprisonment or for penalty. But in this new situation, in a summary trial, you will be able to bring it from the estate of the person. Even the heirs will be responsible if they are trying to escape. Even his business, other businesses will be responsible for all these things. And even the injustice and never said that fraud should be, we can say, pardoned. They have also not said that the cheating should be pardoned. They have only said that those who are not in day-to-day activities, I should be punished for the others' wrongs. And in that sense, they are saying that a civil wrong may be dealt with in a civil manner, but by a magistrate. Magistrate is not out of it. The criminal lawyers are not out of it. They are in it more. Because now, in a civil manner, when the matter is conducted, it will be speedier. It will be, in fact, they demanded that it must be in a summary manner, it must be tried. So their question is very simple. That there is a misconception or misunderstanding. No criminal statute is being removed. On the contrary, more age is being given to the magistrates for concerning. The magistrates are to remain, but with more power, with summary powers, with powers to attach property, with powers to attach estate, and all that is going to happen in this particular thing. As you are asking, the question is because of the terror or because of the deterrence, the people are not appearing. They are not coming to the court. They are trying to avoid the appearance. And do you know, and you also must be knowing, that without the other person appears before the court, the proceeding cannot go on. And they are avoiding because some of them are not responsible in any manner under 141. And when the matter is decided later at a later stage, the judge says, all right, you are discharged. But what about the time consumed by them before being discharged? And so in this manner, let them come before the court because they are not going to be sent to the jail. Let them come before the court because they will be civilly penalized, and definitely more cases will be decided in a speedy manner and in the quickest manner. 138 is staying, is not going.
Thank you, sir. For the next question, I would like to invite Mr. Shailendra. Shailendraji, please go ahead.
Good evening, sir. I would like to ask my question to Ranjit, sir. Sir, so with the step towards decriminalization, how do you think this will be perceived by foreign investors and incoming FDIs?
Well, Shailendra, I would put it this way, that a foreign investor coming to India to invest money, we should be first made aware of the, or will himself make himself aware of the Indian laws. He is bound to make himself aware. Now, if he knows that if I do everything right and I don't indulge in any activity, which is against the law, or I don't do something by which I violate the law, therefore it will be all ease of business for him. But definitely, some of the things which can be done, as I have suggested earlier, about pre-trial mediation or pre-charge mediation or plea bargaining or even compounding, that you can compound your offense, it could ease them to the extent that they will feel that maybe I have committed unintentionally or minor offense or something. Therefore, I can, by compounding, I can do business. So, because India is a very large economy, the number of population, the buyers available here cannot be equaled anywhere else in the world. So everybody wants to come here and will come here and will like to sell their product or set up an industry and sell their product because the business is going to be good here. But at the same time, he must not indulge in any kind of an activity which is dishonest, fraudulent, or to cheat somebody. As long as he understands that, and this discriminalization, as I have understood, is going to happen in a manner that dishonesty, fraudulent, etc. will all stay, but there will be compounding, there will be mediation, etc. That itself is a great thing in favor of the foreign investor, and he will be happy in that regard. So that's how it should be. But I would like to definitely say here that it is our courts infrastructure which needs to be increased. And I have done some cases as an amicus curiae with reference to different states' court infrastructure. This is because it is a state subject. States don't want to invest money in the court infrastructure, increase the number of judges, increase the number of courts, increase the number of, wherewithal. Though we have reached up to taluka level in providing legal services and free legal aid, but we have not been able to have the number of people to command at that position so that the cases can get disposed fast. What does the foreigner want? He wants his cases to be disposed of fast. He doesn't want to come here and for 20 years go on litigating. So the theme should be more as to how you can fast track all this. Thank you.
Right, sir. Thank you so much. Thank you so much, sir. We're just waiting for two more questions that we'll take by some more people. So we've received certain questions from the audiences as well. So they all have very mixed views to this. And I think I would like to take this opportunity to congratulate once again for having given diverse viewpoints of this topic today. I would just invite you to bear with me for a while. We're just waiting for two more speakers to join us who would just open the questions now. Mr. Nanda, I would like to just bring you in if you have any further comments to add.
No, I'm very fine because the discussions are moving in the desired direction. We are bringing out certain issues which the audience would like to always listen. We are having a diverse background which is being redressed at the rightest level. And I feel all will go home more enlightened and putting at rest all the doubts that may have crept in during this entire proposition.
Okay. Abhay, sir, if you would like to add anything, Mr. Bhardwaj.
I've just said that the industries which have given their points, and they have specifically desired that it must be made compoundable. And that is what precisely it is being meant, that a civil wrong may be dealt with within a civil manner, but by the criminal courts itself, in the speedier manner itself, by the summary trial itself, and without the fear of imprisonment. If they come, and they will definitely come, and they will try to negotiate, and they will try to ultimately compound the matters, and it will be very easier in this manner, because revenue generation or the settlement of money disputes is the prime consideration in any kind of these offenses. So that can be definitely done through this process. I said that decriminalization word has caused a lot of problem, which in fact should not have caused, because this is not a case of bringing out away a statute. No sections are being gone, no magistrate is being replaced, no civil judges are coming in place of criminal judges. Criminal judges are going to be there. Only the nature of punishment is being changed from imprisonment to the penalty. That is what this practical the process is meant for.
Right. So I think we have Neha Garg with us. Neha, can you hear us? Please unmute yourself and have the video on, please.
Yes.
Yes, Neha, please go ahead.
Good evening, sir.
Yes, please.
My question is to Bhardwaj, sir. So my question is that do you think decriminalizing Section 42 of the State Financial Corporation Act will help the MSMEs to flourish and contribute to the economic growth of our country?
But let you understand one thing.
Yes.
It is very clearly that this section's maximum is punishable by 2 years and by 2,000 fine as such, or by 6 months, the other part of the offense. It concerns the corporations, warehouses and other things. The question is if you make it compoundable and make it easier.
Right.
It is not removing these sections. There is a misunderstanding. The trial is being put in a different forum, but by the same judge. It may be a magistrate who will conduct again. Even today, it is not a cognizable offense. Even today, a complaint has to be filed. And filing of a complaint would mean that the process has to go through this summons process. Now, summons are difficult to be served. And when they don't appear, again the trial will be prolonged. But if we make it compoundable or punishable by the civil wrong as a civil penalty, I think it will be easier for the system to work. These kind of cases, if they linger on, only because the summons are not served, they linger on because the person is not appearing. And you cannot, in a criminal trial, punish a man without being heard. If it is made into civil nature, ex parte also it can be moved. Even without the presence of the person, if he is avoiding appearance, he can be punished. But because it is a civil law, and in a civil manner, he can be penalized. In a criminal manner, you can't penalize a person behind the back or without his presence. I think you understand my point.
Yes. Yes, sir. Yes, sir. Thank you so much, sir.
Thank you, sir, for your answer. With this, I think we've had a very fruitful, very enriching session that the last 1 hour has given us, has thrown about various points for all of us. Our friends from the audiences have also thrown in their valuable inputs. I'm sure going forward, we will take all that with us, and probably, as Mr. Nanda suggested, we might also submit something to the stakeholders so that all the confusion, all the misnomers or certain queries or clarifications that are required can be drawn in, and probably going forward, it will help to clear the air amongst the public, because at the end of the day, not just foreign investors, even Indian business owners, even small and medium businesses in India have to be protected and have to be considered safe, especially in these times where we are facing unprecedented situations, and we really don't know when all this will get normalized. And going forward, we really don't know what exactly is the new normal. We keep hearing this word every day, but we still are not sure what exactly is the normal going forward. Every day it's changing. The WHO is coming up with new definitions, with new clarifications. So I'm sure going forward, we should have some clarifications coming in. With this, I would like to invite Mrs. Sarika Singh to come and deliver the vote of thanks for us.
Hello, everyone. First of all, I would like to thank our esteemed panelists of this session who have given their precious time to share their valuable opinion on the issue. And it was really insightful and engaging session, as I can see from the comment box. I think it is a right time to have this kind of session because a lot of sectors are facing economic slowdown due to COVID-19 pandemic. I hope government will take further steps to ease doing business in India. Last but not the least, I would like to thank our entire team of Lawyers Voice who has made it possible and successful. Thank you everyone for joining us. With a parting note, stay safe, stay happy.
Thank you.
Thank you so much. Thank you so much,
Thank you.
Sarika.
Namaskar,
With this,
Bhardwaj
we
ji.
bring this.
Namaskar, Nanda ji. Namaskar,
Thank
Mukherjee
you.
sahab.
Thank you.
Thank you.
Thank you so much. With this, we bring our session to an end. We invite all of you to stay tuned, to like our Facebook page, to subscribe to our YouTube channel so that going forward you can receive all the future notifications. And with this, I take your leave. Namaste. Thank you for joining us. Have a good evening. Shubh Ratri.